就医疗或是科学上面的证据来证明。
So one of the reason of acceptance of her illness as occupational disease was even though we plaintiff could not show which chemicals she was exposed and to how high extent of the exposure was, but the judge just accept some possibility of relationship.
所以在黄玉敏的这个案子里面，虽然我们没办法证明或提出证据说，他们是被暴露在哪几种化学物质当中，或是他们暴露的化学物质在那个环境里面它的浓度有多高，但是法官他还是裁定说有那个就是有我们不需要提出这样的确切的证明，但是还是他认可那里有这种可能性会致癌。
And the below sentence is really important because we strongly argued this fact because there are, the company and the government just argued that there are no non-carcinogen in the factory, but so we argued that actually most of chemicals are not tested about their carcinogenity.
OK， 所以这个下面这一章是我们在辩论的一个重点。所以厂商就三星电子那边，他们一直声称说，在厂区里面并没有所谓的致癌物，致癌物的那种化学物质。但是我们自己这边的主张是，所有这些半导体产业他们所用的这些化学物质，并没有被测试，对，就是他们是否是致癌物，并没有经过测试，所以也不能证明说他们没有致癌的可能性，就根本没有被经过测试，怎么知道说他们不会致癌呢
？Go to number 3. So, and on the second line, the judge found a small portion, a very low level of hydrogen chloride was detected in the workstation, and then that means the toxic chemicals, other toxic chemicals, may not have been adjusted perfectly, thoroughly through the ventilation system. So the judge accepted the possibility to exposure to some unknown various chemicals.
那在这一章里面，就是法官他裁定说，因为在调查里面有发现，那个工作场有在他们工作场所里面，那员工被暴露在少量的这 hydrogen chloride 是一种化学物质，有毒的化学物质。那还有就是那个另外一个是在这厂区在生产线上面，他们的被暴露的那些化学物质，其实有可能是因为通风，就是他们厂区的通风的系统可能会交互作用，所以其实通风系统也会让这些员工暴露在更多的化学物质里面。
And let's go to the number 5. So, and the judge made really excellent decision that although the level of exposure was very, very low and even much lower than the threshold limit of exposure, but she seems to have been exposed continuously, long time a day, so it can be possibly some risk factor of cancer.
所以这法官做了一个真的是非常好的一个裁定。那法官认为说，虽然这一些化学物质的剂量是非常少，他们暴露所接触的化学物质剂量是非常少，但是因为是长期的，而且是一直持续的暴露在这些少量的化学物质当中，所以其实是有那个可能性 会导致疾病的产生。
And Hwang Yumi got cancer 2 years after her entrance to the company, so it was very short. But the judge accepted the possibility. There's a kind of different sensitivity from individual to others. He accepted the concept.
那个虽然黄玉米黄玉米这个被害人，其实他在进工厂2年后就被诊断罹患癌症。但是法官他觉得他的裁定，他觉得就是有那个可能性，他接受原告这一边的主张，说有这种可能性会造成，就是这种长期持续暴露在少量的化学物质当中，会造成癌症的产生。
And the judge accepted that the mortality and prevalence rate of semiconductor workers, especially female workers, are higher than the general population, even though the results are not statistically significant.
那法官他也接受说，在半导体产业工厂里面，女性员工他们的死亡率跟罹患疾病的那个几率也是比较高。虽然说有刚才有讲说在那个统计数据上并没有显著的影响，但法官还是接受有这个可能性。
And although the company Samsung, they argued that according to their material from the suppliers, there is no carcinogen. That's the company's argument. But the judge said, okay, I accept your argument, but it's there is no it cannot be effective. I mean, it cannot be influence on this decision because this compensation law do not need any proof of evidence of employer's fault or negligence.
虽然这个三星它一直辩称说，它从它供应商那边进来的那些化学物质里面并没有所谓的致癌物，但是法官就跟三星那边说好，那个可以，我接受你三星那边的说法，但是在那个劳工他们的那个就是员工赔偿的制度里面，并没有说员工就是被害人申请人必须要提出科学证据来证明雇主他的责任，或雇主有他的一些他行为的上面的证据，所以在这里面科学证据员工不需要去证明雇主的过失。
So as you see before, the judge accepted more than 90% of plaintiff's arguments, except one thing. They didn't accept the night shift work and cancer's relationship, and stress and cancer's relationship. They didn't accept it, but except that only those 2 things, all the statements in this court decision were from plaintiff's side.
那在这个案例当中，法官其实他差不多90%都有接受原告这边的主张。那其中有一项法官他们有接受的是原告这边提出在工厂里面，尤其是夜班在上夜班的那些员工，他们跟工作环境还有那个罹癌率的一些关系。
Okay, and the remaining slides will show you some brief judgments on the 3 other failed cases and some a little difference from between the 1-2 cases. But I think I can skip the explanation of the remaining slide.
OK， 那接下来的那个你们的那个答案的语音里面，他有讲到另外3位，就是法官他没有 他没有认定说他们的职灾跟工作环境有关。那所以为了时间的缘故，我就这里我就省略，那我就在这边就说到这里为止。
I will add less comment. So, as I know, this court decision is very progressive and really good, well understand the so-called public health, some important concept in public health. But this court decision was made at June 23rd, but 3 weeks later, the government appealed to High Court. So, and the new judges are more conservative, as I heard. So actually, we are really concerned about the result. And actually, these first victim groups, they decided to go to the Supreme Court, even though it will take a very long time. But this is the first case, I mean, in semiconductor industry, and especially the first lawsuit of Samsung workers in this issue. So I don't know, but I think this court decision is only partial, but very important victory of all of us, because the judge decide not only based on science, but also based on some political and social context. That's what I feel. So I think if we can make more communication in the future, and if we can support each other through direct or indirect ways, then I think we can get better results through the lawsuit struggle. Thank you.
好，虽然说很快，那所以这个他觉得说这个裁定其实是非常的先进。那这是在6月23号他的裁定，在韩国也是第一个。那但是6月23号裁定下来之后的3周。韩国政府决定上诉到高等法院。那听说高等法院的法官是比较保守的，所以非常的担心。那在这个裁定里面，其实我们发现了，就是法官他觉得说并不科学上的确认跟证据并不是必要的。在法官裁定里面，他也把政治跟社会的这一些因素也考虑在里面。所以这个 case 其实也是韩国第一个针对三星电子诉讼员工针对三星电子诉讼的案例。那希望说在未来就是这个案子那个被害人当事人，其实他们也准备了，即使要很久的时间，他们也会继续上诉到最高法院。那希望说以后能够透过彼此的交流跟声援，能够让这种案例就是得到更多的更多的那个力量，跟还有我们能够彼此能够学习更多。那然后以后我们能够有更多的互相的交流跟讨论。
我想接下来我们就请那个就是 Ted Smith 哈，那他来就是说跟我们分享一个，比如说国际针对像这个比如高科技电子业这样的一个比如说诉讼那以及就是说目前的一个国际的一个趋势到底怎么样的发展。
I wanted to just respond a little bit to what I've heard this morning. I don't have a formal presentation, but I think this has been a very thought-provoking conversation, and I've jotted down several notes that I'd like to share with you.
大家好，我现在就是最主要就是要针对到现在为止今天所听到的一些这一些非常令人振奋，也让我觉得很好的一些资讯。因为我没有正式的一个那个PowerPoint 档，所以我就做一些回应就是了。
Before we get going, I'd like to express my appreciation to ECHO and the Environmental Jurists Association and present a couple of gifts. There's a book that we did in Silicon Valley several years ago called Sacred Waters, Lifeblood of Mother Earth. And I know that many of you are very concerned about protecting the water quality here, and I thought that these are some stories that might be helpful. to share experiences. So here's
Thank you. 谢谢。那这里是有关的矽谷的，我刚才陆律师有讲说，我们都很关心水权的事情。那就是很感谢EJA环境法律人协会，还有我的翻译。那但是这本书是有关矽谷、有关水资源的那个书。这其实can I give it this attorney Lou because she is our leading attorney on the water issue. She's also a EJA member. 她也是环境法律人的会员。
The other present, some of you know a book called Challenging the Chip that several of us in this room participated in writing, and I know it's in the process of being translated into Chinese. Wen Ling was one of the key participants in this. There's stories in this book about Taiwan, but also about many other struggles around the world having to do with the electronics industry. So again, I wanted to share this with you.
Thank you. 另外这一本挑战晶片就是矽谷有关半导体产业的一些那个文献记录。那杜文林老师其实在里面有一篇文章，一篇而已吗？还有另外春花妹，你今天有看到另外一个 IBM 报告，所以我们台湾的案例也在这里面。那挑战晶片这一本书真的很好，我跟大家保证。我们现在在看中文了。
There's also stories about the RCA case in Taiwan and the IBM case in the U.S. in that book.
这里面也有在台湾的 RCA 案例，还有那个美国 IBM 员工诉讼的案例。
We didn't know yet about the Samsung case when we wrote that book.
对不起，因为但是我不知道有三星电子的员工的案例，所以还没有在里面。
For the next edition, there will be.
下一本就会有三星的案例了。
And actually, it's been translated into Korean. Dr. Kong and her colleagues were very effective in translating that book, so now it is out in Korean.
所以其实这一本挑战晶片已经有韩文版了，那是Sharp 他们这个已经做出来，在去年就做出来了，很快。
I wanted to very much thank you for inviting me to participate in this forum today. I have long been a big fan of the democracy movement and the environmental justice movement here in Taiwan, and the fact that you have connected them now for many years, I find very inspirational, and I really enjoy learning more about it over the years.
谢谢你邀请我来这里。其实我对台湾的民主化还有那个环境正义的这个运动里面，我长期以来我都非常的关心。
I very much appreciated the comment too earlier on about the Aarhus Convention. That's something that is very important to me. One of my close colleagues who used to work with me at Silicon Valley Toxics Coalition, whose name is Michael Stanley Jones, was one of the people who helped at the UN to get that convention adopted throughout the world and is now continuing to work at the UN on all these issues.
那我今天也真的很振奋，能听到台湾这边律师提到阿尔胡斯公约。那阿尔胡斯公约，我有一个朋友，Michael Stanley Jones，他是我的一个工作伙伴，他就是在联合国那时候在推动联合国那个联合国里面阿尔胡斯公约能够让这些所有国家能够接受。那在未来阿尔胡斯公约其实会在这联合国或是在环境这个议题会有很大的用处。
I think the discussion today about the burden of proof is a really, really important discussion. I actually like better the phrase burden of responsibility that I heard used because I think that actually captures what it is that we're trying to identify here. It's not just a legal device, it's really a sense of moral responsibility. And I think this is underlying the struggles, whether we're talking about the science park expansion or whether we're talking about the Samsung case or whether we're talking about many, many other issues. It really is the question of who really does bear the burden of responsibility.
那今天我们听到就是两个案例里面都有提到提出证据的责任，那就是举证责任。那举证责任的话，其实我本人我比较倾向用责任 burden of responsibility 责任？
谁该负担？
谁该负担这个举证这责任的程度？所以因为这个责任其实这是一个道德性的责任，这个也不只是科学上面的一个责任而已，这是一个道德的问题。
One of the other common elements that struck me about both of the cases that we heard about was the fact that in both cases we had government and the companies working together against the interests of the community and the environment, all in the name of economic development.
那另外一个我发现的是，在这两个可以谈很多的案例里面，其实都是政府跟财团跟公司他们狼狈为奸但是他们来一起对抗就社区还有还有一些环境社区跟环境。那像
In economic development.
所以他们都是用经济发展的名义来做这一些坏事。
And in my experience, this is always the case, and is one of the main reasons why I think it's so important that in any kind of struggle for environmental justice or occupational and environmental health, that we must unite the workers, the community, the residents. It's really the 99% that we need to unite.
那在现在这里面，我们看到有很多，我们都是在为了环境，不管是为了环境，或是为了那个止灾的这一些在做奋斗的时候，我们需要能够团结的是，就在这些案例里面，占了99%的工厂里面的员工，社区里面的人民居民，还有其他很多这些我们这些人，其实就所谓的99%。记得那个我们现在占据华尔街那个99%，就是说就是这些，那1%是另外一边。
I was also struck by the comment that EPA and the administrative agencies are bullying the judiciary. I think that's a very serious problem, and I think that whether we're talking about Taiwan or Korea or the U.S. or any place, the independent judiciary is essential, and I think it's in all of our interest to make sure that we do all we can to ensure that that is a reality and not just some nice words that we don't really pay attention to.
那在这个案例里面，其实我很惊讶看到说我们的环保署就看到环保署跟行政部门他们一起霸凌司法。那不管是在美国、台湾或者在全球任何一个国家，司法独立都是最基本的。那这也不是纸上谈兵，或者只是漂亮的话而已。司法独立必须要坚持，也必须要彻底的落实。
One of the other things that I just am so impressed by is that in both Korea and Taiwan, the work that you are doing is really making history. And I am struck by a quote by a South American poet named Antonio Machado, who said, "There is no road. We are making the road as we walk along." And I think that's exactly what we're doing here.
好。那其实我这次我真的也很印象，等于说印象非常深刻。就对于台湾跟韩国这些案例，因为你们不管是台湾或者在韩国，你们都是在创造历史。那我现在要引用南非一位诗人 Antonio Machado， 他讲的就是没有。
Yes, he said there is no road.
本来是没有路的。
We are making the road as we go along.
我们是在开路，我们一边走一边开路。
Another way of saying there is no path. There is no way that we can see. We have to make it as we go.
因为其实我们往前看，我们看不到有任何就是像这样有任何路，因为其实我们在创造我们在走的路。
It's very beautiful in Spanish when it gets translated through English into Mandarin. I think it's perfect. I'll send you the Spanish.
这其实这本来是西班牙语的，那就念起来会更
更美、更优美。
I also was thinking here today that I stopped practicing law about 25 years ago because I thought that I just couldn't change the world by filing lawsuits. That's why I became a lawyer. I got very frustrated and discouraged, and so I stopped filing lawsuits and I started working for an NGO.
其实我25年前开始开始那个职业当律师，那但是这几年来这么多年来，我觉得以法律途径就是以诉讼来为环境正义，争取环境正义上面，我觉得也是蛮沮丧的，就是有很多其他的例子、失败的例子。那所以这是为什么我决定放弃职业，就是当律师，而变成一个环保团进一个环保的运动者。
But what I see again in Korea and Taiwan is that when lawyers are connected to a social movement, that there is a possibility to actually make change by representing that social movement, not by just acting on your own.
那在台湾跟韩国的例子里面，其实我看到，当律师跟社会运动结合在一起的时候，我们是有那可能能够改变的。所以其实律师参与社运，或律师跟社运的结合，是一股很大的力量。
I am very much impressed with the focus on international human rights. I have not seen very much discussion of that anywhere in the world. So I really think that what you're talking about here is, again, very much on the cutting edge. And I think it's really important that we not only support this effort, but try to encourage this in as many places as possible. And that we increasingly present occupational and environmental health as international human rights issues.
那在这个案例面，其实我也很振奋的看到，我们把那个国际人权条约这一些能够带进来诉讼里面。那用这种策略或这种途径，其实是非常非常先进的，在全球而言非常先进的，很少看到有在环境诉讼里面真的运用到国际人权。那这个真的很需要大家互相鼓励跟互相支持，尤其是在职灾，认为是在职灾这一方面的诉讼的话，其实我们可以运用更多的就是有关国际人权这方面的条款。
I've been on the road now for the last 2 weeks. I've been in Korea, in India, and now in Taiwan. And from what I've seen, I am increasingly persuaded that what we need is a significant shift to try to implement the precautionary principle.
那过去2周，其实我到了我有去韩国、印度，然后现在又来台湾。那在这趟旅程里面，其实我越来越相信，我们必须要做预防原则的一些那个就是预防原则要彻底的能够设立跟落实，预防 precautionary。
And the way I'm thinking about this now, it's clearer to me now than it's ever been that particularly in dealing with the electronics industry, which uses so many chemicals which are themselves very toxic, but also many of which are not tested, and in almost every case where the companies continue to claim secrecy, that in those situations, it seems like it's a very reasonable argument to switch the burden of proof and to say if somebody is harmed when you are using dangerous chemicals, you're using mixtures of chemicals, and you are refusing to disclose, and these chemicals are untested, then it's only fairness, it seems like to me, to say that if somebody is harmed, then the burden should switch to the party who has caused that harm to demonstrate that it's not their responsibility. So I think that's underlying what it is we've been talking about here in both of these cases again this morning. As I say, it's much more clear to me now than it's ever been that that's the direction I think we need to go.
其实在这两个案例里面，我也看到，而且我也坚信，就是说，我们现在在那个电子产业里面，因为电子产业都使用非常非常多的化学物质，而且这些化学物质其实都是
毒性非常强烈，或是说他们根本也没有经过测试，就不知道它们的毒性在哪里。那